to ensure that we are moving in tandem with the national system. It's good to see the Honorable Minister for Communication and Digitalization here, and I'm sure she sometimes gets a bit tired of all the different messages that I send to her on different issues. At every turn, it's an infrastructural machinery, and that in that infrastructure, everything must be properly situated and covered by law, and must have verification, validation, authentication. Everything must be in place. So it's not a simple situation. We are doing it step by step. And indeed, we've taken a long time in one location because we want to make sure that when we move it, we don't carry along mistakes.
Before you, let me ask this follow-up question. From what you have discussed, probably the entire value chain, the legal delivery system, have that been factored in the legal training?
Yes, we have consistent training. In fact, change management is a big thing. And that we have to train clerks, interpreters, registrars, registry staff, judges. And you know, this is a community in which there's a lot of technophobia. So you have to deal with the technophobia. You have to you have to deal with getting people interested in using the machines. And then the stakeholders, the citizens.
My interest was at the schools, the faculties, and the law school. Have their training taken into account the e-system?
We are developing curriculum for that, to introduce, because really every aspect of law now has to look at the e-angle. Contracts are virtually done online now, banking, financing. So the law schools really ought to be incorporating e-thinking.
Thank you, Your Ladyship. Of course, the last question will be on the common normal issue as to entry into the law school, and not only entry, leaving the law school. Indeed, for some of us who finished the law school in the 90s, we just more or less entered the law school. And after the 4 years, we left. But it appears that the young people that you meet, they tell you it's a nightmare to be able to enter the law school. Of course, Ghana has grown. We've become far bigger than what Ghana was. There are more schools training people to be lawyers. The other aspect is when they enter, after going through all this hell to enter, it takes them another hell to leave. That's always been the case. And as I said, for us, we were during our time, people would be called to the bar in October, a few will be referred. April, they get a mini call, and that's the end of it. But you ever hear people talking about having been referred for so many times, and indeed, you only pray that they're able to leave within the shortest time. What would you think you can bring on board to help address this problem, not completely eradicate this situation, because it depends on other things apart from your administration? What would you think we should do to be able to make progress in this situation, in this regard?
I think, I'm sure when you went to law school, you were a full-time student and you were quite young. That was my situation, straight from sixth form. We just studied. Now many people in the law school are working. And I think that affects their ability to really engage with the law and pass the exams. If you recall, in the last 6 months, at least 1,000 people have been called to the bar. the last major call had 860 or so people being called to the bar. We had a mini call a few weeks ago, more than almost 200 people. I mean, a mini call having 200 people, that's unprecedented. So they are coming out and they are going in. But I think that the journey is a struggle for working people.
Yes.
Thank you very much. Thank you very much, Chairman. Your Ladyship, Justice Gertrude Araba Eseba-Saki. Torkono. Isaba. Don't worry, I'm a Kusasi man, so from Sirim. So the minority side of this committee actually had reservations about participating in your vetting this morning because you participated in the decision involving Honorable James Quayson. You asked that his name be struck off the records of members of parliament. But as a member of the panel and as a court, you did not give a reasoned judgment. So as we speak, we don't know the basis on which the court arrived at that conclusion. And there's uncertainty among us as members of parliament, knowing that our Supreme Court is also our constitutional court that should guide us as a country in terms of how we run public affairs. We would have thought that on a matter in which we were so divided in terms of the two political parties, a matter that was litigated from the very day in which this parliament was sworn in, the night of the swearing in of this parliament, till the 17th of May, when you gave your ruling. It's a very divisive matter. We thought you would have carried all of us along by giving a reasoned judgment. Because when you give the judgment and you don't give the reasons, in between, people fill it with propaganda, speculation, and that just divides the country. It doesn't help us to move along together as one people. So we wanted the reasoning in that judgment to be able to really evaluate you, in addition to all the things that you have given us. But we've reached a negotiated position with our colleagues in which we've been assured that we will not vote on you today after this hearing, and that when we finish today, when the Supreme Court gives the reason, we will have another opportunity to now assess you on the basis of the quality of the reasoning of the court. And then we can take a decision. On that basis, I have no question for you today. I would wait for that day when we have the opportunity, and I will focus my questions on the reasoning that you will give in that matter.
Can I have an answer for your no question?
Yes, please.
Honorable Member, can I have an answer for your no question?
I will give you the permission. Please proceed.
And my answer is that I have given hundreds of judgments from High Court till now. And I think that it would have been a really great relief to know that I am assessed on my work as a whole. And then two, the judgments of the Supreme Court. You know, the Supreme Court is not a court unless 5 people are sitting. And in constitutional matters, we are 7. So 7 people are working together. And that's why very often, indeed, almost invariably, every judgment given by the Supreme Court comes out, the reasons come out long after the orders and the rulings, because that's how we work. Everybody has to check the jots and the tittles before you get the final script.
Yes, I thought you said you're not very much. Or if you want to ask a question,
Mr. Chairman,
you have 3 opportunities.
Thank you very much, Mr. Chairman.
No, wait. Oh. He has 3 questions. You commented that you may not ask further questions. But if you want to ask further questions, I'll give you the opportunity.
No, I'm not asking a question. She gave a response to my comment that I would reserve my questions.
No, and she responded to the issue as to why there is no reasons on the day they pronounced the judgment. That's the response she gave.
She was hoping that I would take a decision based on all the decisions that she has already handed, both as
if you want
High
to
Court,
ask, please go ahead and ask a question.
No, I'm just saying that this specific decision for me is the most influential. That's why I want to focus on it.
Very well. Yes.
Thank you very much, Mr. Chair. Justice Gertrude Araba Saba Saki Torkono, I congratulate you on your nomination.
Thank you.
The name is
Lord,
actually Torkono, not Torkono.
Torkono. Of course, I'm also from Dagbong, so sometimes you have to understand that the phonetics would vary. Thank you very much for the collection. So, my lady, when you were at the commercial court, I was then in the law school, and your court was more like, if you like, the Mecca for some of the law students. It was a place that we used to go to add to our knowledge of company law that was being taught by Mr. Seta Santi.
Thank you.
I remember Justice Tanko as well. His court used to also be packed to the rafters. So we feel that you've made your mark. But
thank you.
I have a few questions for you. First, let's go to page 12 of your CV on books and plays. Books and plays. Gertrude Torkono, 2010. The Child and the Rainbow. Anthropology of Poetry, printed by Combat Impressions. Can you tell us something about that book? I like children a lot, so I think that maybe it has to do with children. Maybe I'll learn a thing or two.
There's hardly anything about children in it. I think the child in the title refers to myself. And I wrote it at a time when I was not a child. But that collection really dealt with my Christian experience. So it was a collection of poetry that had come out of me during my times of Bible study and just thinking about Christian doctrine and having Christian experiences. And that's why that particular collection is called The Child in the Rainbow.
Thank you very much. My Lord, the Supreme Court gave a decision, and I'm making reference to the matter that my colleague, Honorable Ayariga, just referred to. The panel was made up of Justice Jones Doche as presiding judge, Nene Amegache, Justice Nene Amegache, Justice Mariam Owusu, Justice Gertrude Torkono, Justice Professor Henrietta Mensah Bunsu, Justice Emmanuel Yoni Kolendi, and Justice Baba Akayensu. It was a unanimous decision. You said that you filed a judgment at the court's registry on the 7th of June. Essentially, what the court did was to declare unconstitutional the election of Honorable Jeche Kwesin, and that his election more or less violates and contaminates the Constitution under Article 94(2). Now, the court made reference, you cited a number of your previous decisions, including the matter involving Senator Rawlings, which, settles the matter. Oh, please, take it easy. Allow me. You said you won't ask questions, so let me ask the question for you. Please. You said...
Order, please.
I'll ask the question for you. I'll ask the question for you. My lady, the matter in reference has to do with the decision of the Supreme Court, not decision of Justice Torkono. How do you view the position that it appears that the decision is being imposed on one person? You are not even the presiding judge to start with. And secondly, assuming without admitting that you are the one writing the judgment, I'm not saying you are the one writing the judgment. Is it the decision of the justice writing the judgment? Are you the one who volunteers, or is the presiding judge who nominates somebody to write the judgment? Thank you very much, my Lord.
My Lord, you can ignore the first part of the question. Just the second part that you may answer.
Well, because this is a public hearing, I thought that I should answer, I should inquire about how he seems to have seen the ruling judgment, because I haven't seen it. I know, you see, the way our court works, we sit in conference, we sit in conference over every decision, every matter before us. As I said, it's not a court unless there are 5 people or 7 people. And so all these people will sit in conference. Everybody will present their position, their evaluation. We will agree the orders, the conclusion. We will craft the orders and the rulings. We will share it. Everybody will approve. And then it will be written. Sometimes, I have actually been on a panel in which different judges wrote different parts of the judgment. It was a very interesting experience. Sometimes one person will write it. Sometimes more than 2 people will write it. And in this particular situation, we had concluded on our orders and rulings, and we gave that to the public. And the judgment is currently a work in progress.
Thank you very much, my lady, for the clarification on this matter. In other words, it is not one person's decision, it's the court's decision. My lady, when you appeared before this committee in 2019, I was then selling petrol. I was then working at National Petroleum Authority, so I was not here. Now I'm here. One of the questions that was asked of you had to do with your demeanor on the bench. Some said you were confrontational, you're uncompromising, you were fastidious, you were meticulous, and so on and so forth. But I have, like I said, seen you in action. And I see that you are very, very meticulous. I believe that we are vetting you today not as a justice of the Supreme Court, as the chief administrator, head of the judiciary, has to do with administration. And I believe your meticulousness would come to bear because you can't afford to make mistakes. And so those observations that had previously been made, I believe, were adequately answered, would now come to stand instead of you and then make your administration, I believe, a very, memorable one. What would you want to be remembered with long after you have left the bench? Long after you have served as Chief Justice of the Republic of Ghana, at least for the next 10 years?
An increase in efficiency. And if as a lawyer, you would have noticed that the rules of court have laced within them timelines. And so I would be focusing very much on what strategic interventions. Indeed, the current strategic plan of the Judicial Service has that as one of the first action lines. What interventions to ensure that we adhere to the timelines that the law anticipates in the delivery of our work. I would also want to be remembered for incorporating technology effectively. I'd want to be remembered for an increase in capacity building, raising the capacity of the entire judicial service so high that we are known for excellence, among other things.
Thank you very much. I wish you well, my lady.
You're done. Yes, Vera.
Thank you. Thank you, Mr. Chairman. And, good morning, Honorable Nominee, Your Ladyship.
Good morning.
I want to take you to page 2 of your CV. I just found something very curious there. And in January 1969 to June 1973, Ejumako Local Government Primary School and Ejumako Methodist Middle School, and you have into brackets class 2 to middle school form 1. And you have another bracket that says, I escaped class 5. Would you want to share with this committee what those circumstances were? Thank you.
I know your committee is meticulous. You calculate the years and the dates. And I knew that if you calculated this, you would find that the class levels I was supposed to have been in would be short of 1 year. So I needed to explain to you that I didn't go to class 5. I was jumped. I was under the authority of my parents and my teachers, and that's what they thought I should do.
Thank you. Thank you for that explanation. My second question has to do with, of course, looking at what would you say will be the 5 topmost qualities that a Chief Justice must have, and whether you embody those qualities. Not in any particular order, you can just share them with us. Thank you.
I think a very deep knowledge of the law, because our institution is one that must be a standard bearer and must be a protector of the rule of law. So the Chief Justice must have a very deep knowledge of the law and the philosophies of the law and how they operate nitty-gritty. The Chief Justice must be a person with emotional intelligence, able to deal with all the people. I think a Chief Justice must also be progressive in thinking, because you are managing a resource for the country, the administration of justice. A Chief Justice, I've given you 3. And you want 5. I think the Chief Justice must have that sense of responsibility to the entire country, because the weakest person needs justice. And so you must have that sense of responsibility and compassion. And last, the Chief Justice should be able to network with every community, because our work is done in communities.
Thank you, Your Ladyship. I think my final question would rest on maybe one of the ingredients I expected you to mention, which is personal integrity, because it's become very important in the scheme of things in this country for now. One of my colleagues earlier asked you about the perception that the Supreme Court is become an appendage of the executive. And I think you try to give us some responses to that effect. I will want to go back on that and just want to find out from you that we have citizens who live online. We call them netizens. And they come up with all sorts of opinions and views about everything that happens within our judicial system. Would you say that you'll be able, would you be able to tell this committee how we got here as a nation where all of us have become suspicious of the Supreme Court? All of us. And allow me to ask my question. Where all of us have become suspicious of a lot of the decisions and rulings that emanate from the Supreme Court, and what you will do to eradicate that negative perception, whether rightly or wrongly, and to give us a better face of the Supreme Court. Thank you.
Well, on the question of personal integrity, I thought that was an unquestioned, because I think that anyone who has interacted with me knows that I don't compromise on that. When it comes to the multiplicity of voices on the internet, on opinions about the courts and the Supreme Court, I think that an excellent answer or an excellent help tool will be to constantly put out the data on our work. So for instance, if at a material time we're dealing with the court, our court is dealing with 200 appeals, and none of them has to do with anybody in the political space. We're dealing with public interest actions, originating actions. I'm sorry, I have a 12 o'clock alarm. It's to help me know that the day is, yes, thank you. So the data will help us, because honestly, the number of cases that involve persons in the political space are so few compared to the work we do. Perhaps the ordinary citizen doesn't talk too much about what they have in court, and maybe those in the political space talk a lot about what they have in court, and that's why that is there. And putting out the data, I guess, will help to give a sense of proportion.
Yes, Honorable Boama.
Thank you very much, Chairman, and congratulations, my lady.
Thank you.
My question one is taken from your answers you gave to this committee as far back as 2019. And the report of the committee on your answers to a question on judicial reforms in Ghana's business environment. You gave an elaborate answer on how our asset register was not properly used, difficulty in judges getting information from the company's registry, and so forth. The Companies Act fortunately came into being in 2019. Can you share with this committee some of the challenges you had with the previous act and how this new act has helped with the business environment or reforms that you spoke about when you appeared before us in 2019? Thank you.
I think that my answer, if I recall correctly, dealt a lot with properties, and the fact that executing judgments was a nightmare because you could hardly guarantee property ownership from the records from our land registry and other property registries. The judicial service is constantly engaging in different programs. And we have been through what we call the Business Enabling Environment Program. We are currently going through the Business Regulatory Regime initiatives, both of them with the Ministry of Trade. And in those programs, we are responsible for the enforcing contract segments. And what we do is design strategies to ensure that our work is made more efficient, and then engage other stakeholders whose work affects us. So when it comes to property registration, I recall that a few years ago, we requested that through local government, we should have access to the property rates registries, so that could help us verify home ownership during execution processes. So those are some of the initiatives. But I must say that it's in the trial court that a judge really comes face to face with the problems. And so now, and I have been out of the trial court for more than 10 years. So now as an administrator, I'm going to engage seriously again with the problems faced by trial judges so that we can find solutions.
Chairman, my second question is that those around this table are politicians, and when it suits us, we make all sorts of promises to the public for obvious reasons. My lady, let me refer you to Chapter 8 of our Constitution. And the chairman doesn't want us to be asking questions that you are knowledgeable about, but this one is it's about the executive, and particularly Article 71(1)(b). 71(1)(b), for the benefit of our listening public. Okay, 71(1)(b). The salaries, the side note is determination of certain emoluments. The salaries and allowances payable and the facilities and privileges available to 1B, the Chief Justice and other justices of the Superior Court of Judicature. I looked at Article 290 and found that this chapter is an entrenched provision of our Constitution. And elaborate procedures have been set out for the amendment of those provisions. And this is what most people talk about as, or call, the ex gratia. What is your view? Because previously, you spoke about in support of some constitutional reforms and reviews by the Constitutional Review Commission. What is your take on this public debate on ex gratia? Thank you. Which affects your office and the office of other justices of the Superior Court.
I think that consistently the Association of Magistrates and Judges have responded to the question of ex gratia for judges and made it very clear that judges don't receive ex gratia. We continue in office. We don't go anywhere until we retire. We don't have a cycle. And therefore, the discussion of ex gratia is not at all applicable to us. And this specific provision, where our names are mentioned, deals with how our salaries are set. And Article 71, as you know, there's a committee, a presidential committee that does that work. And the framers of the Constitution thought that that was the appropriate thing to keep us independent. And we are not the only persons subject to it. But you are right that this is an entrenched provision. And it can only be changed by very elaborate procedures.
Thank you, my lady. My last question is on your CV. Hobbies. Watching movies. Obviously, Kuma Wood. And I'm sure you like Kuma Wood. Reading, writing, and evangelism. 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 What is evangelism and what do you do? Do you have time to go out to preach the word of God with this very difficult duty as a Justice of the Supreme Court and now the Chief Justice of me? Thank you very much and congratulations.
Evangelism is informing anyone that salvation lies in no other person than the Lord Jesus Christ, and that all have sinned and fall short of the glory of God. Amen. And you ask whether I have time. I think that anyone expresses their core beliefs consistently in whatever they do and however they spend their time. A previous questioner asked me, the honorable member asked me about my book, The Child in the Rainbow. That's a writing that expresses my faith, and I do that all the time. And then I also lace it into my conversations. And I hope that anybody listening now will know that. John 3:16. That for God so loved the world, he gave his only begotten Son, that whosoever believes in him shall not perish, but have everlasting life. Thank you.
The comment at the table is that John 3:16 means something else to other people.
In fact, to us, John 3:16 or Napo. Napo.
Yes, Honorable Gaga.
There is only one source for John 3:16.
Your Ladyship. Your Ladyship, if you're given the nod, you'd be the head of the judicial arm of government, one of the three arms. Now, that arm of government has not been spared of criticism. And some of the criticisms can be described as perceptions or real. I'll just give you quite a number of them. First of all, the judiciary has been accused of bias, especially when it is handling political cases, so to speak. In fact, some have argued that in recent times, the Supreme Court has developed the appetite to hand down unanimous verdicts when it is handling political cases. The judiciary has also been accused of delayed justice delivery. Delayed justice delivery. And unfortunately, corruption. Your Ladyship, if you are given the nod, what steps would you take to erase some of those perceptions, particularly the one that borders on bias when the court is seized with the so-called political cases? Now, this matter gained prominence when our Minister for National Security spoke in a sensitization workshop when the National Security Strategy was launched. And these were the words of the Minister for National Security. He said, "Injustice," and I'm quoting him, "occasioned as a result of the absence of an effective justice delivery system or delayed justice or biased justice is certainly a threat to national security. Indeed, when injustice abounds, particularly in situations where the bench, which is considered the final arbiter of disputes, is deemed biased, citizens tend to take the law into their own hands, and most times without recourse to the established systems of justice delivery." Unquote. The source is My Joy Online, dated 8th April 2022. Honorable Obiamwa.
My Lord, please respond to the question.
He asked, his question is, I have captured two: bias from unanimous decisions and corruption. There was a second one.
Delayed justice.
Delayed, yes. All right. On the issue of unanimous decisions, I think that whenever you encounter a unanimous decision, it tells you that the law is totally on the side of the position taken by the court. That every member of the court, in fidelity to their judicial oath, cannot take a different position. It tells you that that is what the law is. So the only response is to learn from what the law says. So it's not a matter of bias. It's a matter of the legal position. Then, on the issue of corruption within the judiciary, I think that from my experience, I have come to understand how these perceptions abound. As I said, the judicial service has more than 7,000 employees. Only 400 or so are part of the judiciary. Anyone who presents themselves as able to take money on behalf of a judge gives that perception. And very often, we as judges, including those of us with the reputation of being unbribable, find ourselves in that corner where people go out and present that they are going to give you money. And others believe it because they don't know it. So they don't know that you are unbribable. So there's a whole market, we call it judicial predators. There's a whole predatory group around that function. And that is something that we constantly try to address in our study of ethics, both for judges and for staff. So there are interventions, they just have to be deepened. And then for the community to understand, this is something I would really love to tell Ghanaians, that for every 10 people who tell you, give me money for a judge, you can be sure that 9 likely is going into that person's pocket and not to a judge. So please, don't give money to people to take to judges because it's their own market. It's unfortunate that that perception has prevailed because of the nature of our work. Our work is extremely technical. Sometimes people lose cases because they didn't abide with rules of court, they didn't abide with rules of evidence, they didn't abide with substantive law precepts, and so they lose the case and they don't understand. The law is difficult. That's why law school is difficult. And so when people lose cases, they tend to wonder why they lost. And then they come up with all sorts of notions. And so if you ask me, I would actively engage the community, as my predecessors have done. I'll heighten it, and I would speak very aggressively about being wary of those who present that they can give money to judges.
Your Ladyship, in response to an earlier question by the Honorable Zuera, you spoke about the qualities of a Chief Justice. Now, I'd like to know from you, I know ever since you got elevated to the Supreme Court bench, you participated in determining quite a number of cases which bordered on constitutional interpretation. Now, what is your judicial philosophy when it comes to constitutional interpretation?
I think that generally, when you look at the theories around judicial philosophy, I can describe myself as a textualist. I'm always interested in the context, because I'm interested in the text, I'm interested in the context. And that's what I try to do in every work. What did the law say? And what is the current context? What are the facts of this particular matter? And so that's my answer.
Okay, so Your Ladyship, this is a follow-up question on the view.
Ask your question. If there's a need to give you another one, I'll give you, but you ask your question.
Very well, Honorable Speaker. So, if I understood you well, you're a textualist. So, what views would you then have on theories such as a living constitution as espoused into for an attorney general, so that the constitution, when you are interpreting it and the need arises, you must treat it as a living constitution because it evolves over time? What would be your view then, having stated categorically that you are a textualist? What would you do in a situation like that?
I would not be an activist in the sense of reading into what how the Constitution ought to be interpreted just because society has evolved or changed or whatever. I will consistently ask what was in the mind of the framers of the Constitution, what are these particular facts, and I would read the Constitution as a whole. And then I would also look at all the supporting statutes and the regulations. You know, lawmakers, I have a very healthy respect for lawmakers. Lawmakers do a thoroughly good job. And so it's important to always take a deep dive into all the different arenas of legality around a particular question. And that's why I say I'm a textualist. I'll look at the text and the context before I come to a conclusion.
Last question. Oh, please, please. My lady, the career magistrate program, which was instituted some time ago, was meant to solve a specific problem at the time because not too many lawyers wanted to join the bench at that level. Now, I am reliably informed that some career magistrates have been cleared to do further studies. And as a result, quite a number have now been called to the bar. Your ladyship, if you are given the nod, what do you intend to do with those career magistrates who have now become lawyers in terms of their elevation and what have you? Because originally they were employed as career magistrates. The idea was that they would stay there. But now they have become lawyers. How do you intend to deal with them, your ladyship?
As you know, the Chief Justice can never take a decision alone. So these decisions are taken with the Judicial Council. These decisions are taken with management. And so I would rather get the views of my community in the way forward. But the Judicial Service, as I said, is a human institution. So we had a certain position, the career magistrates came in. The understanding was that they appreciated that they would remain magistrates. But the humans, and they decided that they have aspirations. They want to study. And so there's been a review of the system. I guess there will have to be a constant review until we reach total equilibrium.
Yes, Honorable Minister for Communication.
Congratulations, Your Ladyship. I've
Thank
known
you
you for over 30 years and admire not just your intellect, but your personality and the principles that guide you in your life and work.
Thank you.
And I've also worked closely with you on the e-Justice project, which you chair and have oversight of. I know a lot has been done to use digital technology to improve the efficiency and output of the judicial service. However, challenges still persist. So what are some of those, and how will you work to resolve them?
I think a constant challenge will be how to move the system to what you and I call the last man. The last man is the person living in a village who hasn't got access to Wi-Fi easily. And so we always have to design the manual side and ensure that the rules of operation can be engaged both digitally and manually without putting anybody at a disadvantage. And so that's a principal challenge. It's an ongoing process. And I think that even in advanced countries, you can hardly find a totally digitized system. And so the e-Justice will have to constantly grow at that rate. And we may find that 40 years from now, maybe there are still people who are insisting on living manually. And we have to provide for their access to justice. So it's a process we have to work with.
Thank you. I give you assurance that we stand ready to support you in this endeavor.
I'm grateful.
You've been involved in the practical administration of justice literally all your life, both as a practicing lawyer and a judge. And you've seen the evolution of this sector. and the impact that some of the developments ongoing in the sector may have had on the quality of advocacy at the bar. What suggestions do you have to improve upon that, if indeed there are challenges with the quality of advocacy at the bar?
I think that continuing legal education is critical. It's legal education in subjects that are identified as a necessary source of learning, or the need to increase capacity in at every material time. Many countries require that lawyers go through study in particular subjects throughout the year, a certain number of hours, etc. And I know that there's a brisk conversation going on about it, and that's something I'll engage the bar on. There's already a process, or there's already a program in place, and I'll engage the bar on actively about it. That is needed for increasing the quality of advocacy, because advocacy is not just the oral presentation, but even the quality of pleadings and the quality of appreciation of the rules of court. And if there's a bad lawyer, or there's bad lawyering, not bad lawyer, but bad lawyering, then you know that the poor citizen may lose a case when they didn't need to.
In 2012, Honorable Adamu Dramani Sakande, the then NPP MP for Bawku Central, was convicted by an Accra High Court after being found guilty of perjury and forgery. This decision was hailed by the NDC, leading to a by-election which brought Honorable Mahama Ayariga to Parliament. I have no doubt.
Honorable, for the record, there was no by-election.
Okay. Okay. Which led to Honorable Mahama Ayariga coming to Parliament.
Chairman,
I have no doubt.
That's also not true.
That despite the fact that
I was in Parliament before.
I have no doubt, as Member of Parliament for Bawku Central in 2012.
Can you proceed with the question and leave the end of the topic?
Mr. Chairman, I have no doubt that despite the fact that losing parties and their supporters may not like the outcome of the cases, they utilize the mechanisms of the judicial system, including the review process, to see if they can overturn it. Or they learn to live with it, just like the MPP did in 2012. In view of your answer on the allegation of bias due to unanimous decisions being an indication that the decision confirms the legal position, would you advise our friends on the other side who seem unhappy at the James Kwachi case?
Honorable, can you rephrase your question, please? She has no business advising any side. Please. If you want to ask a question on the law,
okay,
please do.
Would you encourage all parties before the courts to use the legal processes to advance whatever position that they want, or live with the decisions of the courts, whether they like it or not? Thank you.
The courts produce their rulings and their judgments, and beyond that, we have no other opinions.
Yes, Honorable Fuseja.
Congratulations, my lady.
Thank you.
My lady, the courts are choked. Litigation is expensive, and we all agree that it takes too long a time for litigants to get justice, what will you do in promoting alternative dispute resolution if you are given the nod as the Chief Justice?
I'm very grateful for that question. A lot of work has been done. I intend to increase the tempo of that work. As you know, we have CI 133 that was introduced in the as an amendment to CI 47 to allow for pre-trial settlement of commercial matters, both at the circuit court and at the High Court. And so that means that in every commercial matter now, the litigants can engage with pre-trial settlement. But as you know, mediation can be expensive because mediators have to be paid. Of course, they are not paid at commercial premium, but they have to be paid. At least there has to be a budget for it. And so I will engage all those involved in supporting ADR, because really it's the best gift to any disputing group. There's no appeal because the outcome is a contract. There's no appeal. So litigation ends very quickly, and you are not confined to the claims you brought to court. You can always negotiate a better deal for yourself. So I will work assiduously.
I am happy, and I'll be watching out when you are giving the nod to see how you help ADR progress.
Thank you very much for that promise. Because of you, I will work.
Thank you. My next will be to know your favorite Chief Justice or Justices, your reason for making them your favorite, and what you can do to improve what you like about them.
Kindly allow me not to choose a favorite. I have worked under 4 Chief Justices, and I have enjoyed working under all of them. Currently, I'm working under an acting Chief Justice, and I'm enjoying working under him. And so do allow me not to choose a favorite. And I have found that all our Chief Justices have been excellent people. Those I have worked under.
But you can answer the next bit without mentioning names, what you like about things they did, and what you seek to do even more in respect of the things you
Honorable
like about
Elizabeth Tejari, she has answered. She has worked all of them. They are very good. So if you want her to tell you what more she can add, I think she has answered that question, even what legacy she wants to leave. So I'll suggest that you ask another question, please.
Well, I'll let it go. My next will be your take on custodial punishment in respect of sentences that allow judges to either give a fine or a custodial sentence. Your take on that one, because we know that prisons are choked.
I agree with you. Penalties are designed to be reformatory. And so I think that if fines can solve the problem, then it's best not to send one more person into custody.
I wish you all the best.
Thank you very much.
Honorable Korte.
Thank you very much, Mr. Chair. Your leadership, congratulations on your nominations.
Thank you, sir.
Mr. Chair, one of the challenges that the Regional Coordinating Council continuously is faced with as issues of delay in justice about land cases in courts. We know that the land tenure system in this country clearly does not encourage people, if you like, to wait for the processes to go through before even they commence work on their land. Currently, as we speak, there are so many land cases, land dispute cases in courts. One example that I can cite was just around Botiman that has taken 23 years in court. What do you think can be done in delivering justice in time so as to boost the confidence of the ordinary Ghanaian who want to go through due process in determining the legitimate owner of a land?
I think an increased use of technology. We've been looking at technology that allows the superimposition of plans very quickly and clearly when cases are commenced. And that's one area that I'll be extremely interested in moving along very quickly. Because a lot of the delay comes not from the fact of the conflict, but from deciding what exactly the issues are and how to resolve those issues. And then also, sometimes parties deliberately start a case in court and don't want it to end. And sometimes somebody gets an injunction and then he goes to sleep. And because of the independence of the judiciary, it is not our remit to wake cases up when parties have not come to court. So we have to begin a new engagement with what are case management rules. If a plaintiff starts a case and is not following it up, how do we strike it off? If after certain conditions. So technology, case management rules again, and then training, increasing the capacity of judges and also lawyers on practical issues. I understand, I hear what you are saying on different levels, and I'm answering on different levels.
Thank you very much. Let me borrow some of the words you used in your earlier responses to questions that were posed by my colleagues. Responsibility, compassion, and network with the community. Now, like Honorable Obiamo earlier said, I'm sure Honorable Obiamo in the last 20 years may not have engaged in continuous education, but is a good lawyer. There's this issue going around about a decision that is likely to emerge from the quarters of the judiciary regarding continuous education of legal practitioners. What are your views on this matter? Legal education, sorry.
I recall that she spoke to that a couple of minutes ago. If there's any direction that you want to take, but otherwise, she has responded on a question like that.
Mr. Speaker, further and better particulars will not be bad at all.
Yes, my Lord.
Regulation is a part of professionalism, and I think that the conversations around regulating our profession are appropriate. If the Judicial Council, the General Legal Council, the Board of Legal Education want certain interventions to increase professionalism, it is useful that the stakeholders give their feedback, and then everybody arrives at a good position that will be complied with. That would be my answer.
Thank you very much. Mr. Speaker, my final question will be the verse that she eloquently quoted. How would you balance your position as a devout Christian, evangelism and the practice and the legal practice? Well, that's what you put it, if I should quote what you said earlier. So with your belief and a Chief Justice, somebody commits a crime, how do you balance the two?
I can assure you there's no conflict. There's no conflict. The law is the law, and Christian doctrine is Christian doctrine. And where they merge, that's fine. Where they don't merge, my work in the law is in the law.
The Speaker, a follow-up. So in church, you will believe what the Bible says, and then in court, you believe what the law says.
Absolutely, because in church, I'm required to be true to whatever circumstance I'm in. That's what integrity is. In court, I'm to abide by the law.
Thank you very much, Mr. Speaker.
Any more from here?
Thank you very much, Mr. Chairman. Mr. Chairman, my first question has to do with the issue of JUSAC. The staff of JUSAC, as reported, have expressed issues about intimidation and coercion anytime they want to express their unhappiness about the work environment. In 2019, for example, the leadership of JUSAC were almost sacked when they embarked on a strike. Just yesterday, the workers of the Judicial Service of Ghana were virtually forced to open the courtrooms for the Supreme Court to sit. These acts of intimidation and coercion are against the ILO Convention number 87. Only recently, the Judicial Service Workers Association expressed their happiness about the environment created by your predecessor, Justice Enimiabua. And they commended him for maintaining a friendly work environment. What assurances will you give the Judicial Service Association of Ghana on issues about intimidation and coercion, especially on their leadership, as far as their job security is concerned, when they express their unhappiness about the work environment?
I think that I said earlier that I've been in meetings with them, even though I'm not in office yet. I was co-opted to sit in, and we had very cordial meetings regarding the current situation. But apart from that, I think what happened regarding the opening of doors had nothing to do with their strike, because the court doors are not. The court doors are under the administration of management. And so long as citizens were standing outside, it was important to attend to the citizens. And I believe that those issues have been ironed out.
Madam, recently, Supreme Court judges occupying official bungalows were evacuated and the bungalows demolished in the name of a national cathedral. How much, what is the accommodation situation of these affected judges, and how much has it cost the Judicial Service so far to provide alternative accommodation for these judges?
To the best of my information, every judge who needs to be accommodated is accommodated.
My question is not fully answered.
She said, has it cost you anything? more, or how much has it cost you, if you know, that to accommodate the judges who were relocated?
Because I haven't been part of management in that capacity, I do not know about values.
Madam, my next one is on, you made mention of technology. Cybercrime today is one of the most complex issues in jurisprudence. Issues about the dangers AI is bringing, issues about deepfake, and other such technological advancements have made issues about gathering evidence and facts very, very technical and difficult. In your estimation, how prepared as a country are we towards addressing these issues, not to make it difficult for the judiciary to be able to dispense justice and fairness?
I think that generally we are doing well as a country, seeing that we don't have so much in resources. There may have been some incidents regarding bank accounts, etc. But if you notice, we regularly receive alerts when there are problems. That is my perception as a citizen. When it comes to e-justice, I agree with you. Ensuring the integrity of documentation and the security of personal records within the justice sector and the security of the system is a huge part of the cost. It's a huge part of the cost, and it's a necessary part of the cost. You cannot take your eyes off it. So every step we take, we have to ensure that investment is made in the integrity of records and the protection of records. And that's why we are moving slowly. It's one of the reasons why we seem to be moving slowly.
Yes, Dr. Omar.
Thank you, Chairman. Madam, congratulations.
Thank you, sir.
Chairman, my first question or concern has got something to do with minors. I mean, those in US, the definition is under 18, but when it comes to alcohol, tobacco, and other antisocial behaviors, it's under 21. To be honest, these variables are independent variables of insecurity with very high degree of integration in our society today. I've been going through the law books. I'm not a lawyer, so forgive me. I haven't seen any specific law that controls the involvement and participation of these antisocial behaviors when it comes to these factors. If there is, let me know. If it's not, I don't know if you consider that, I mean, in your jurisdiction to do something about it, because it's really, really, really being dysfunctional to the performance of our republic. I mean, it's costing us economically. So I want to find out if there is a law that really strictly deals with this situation or not. If not, what will you do? If it is, are we really enforcing it? That's my first question. Thank you, Chairman.
You know, we have very robust systems for... Are you listening, sir? We have very robust system for managing administration of justice around children. The Juvenile Act. We have special courts for children, special rules for children, and we are very particular about them. We have good systems. But on a national scale, if I'm hearing you right, I think identity, ensuring that people show their identity when they are buying alcohol, they show that they really are qualified to engage in particular transactions. That is outside our hands. Or what I mean by power is the judiciary. That's a matter of, I think the administration of that is totally outside our remit. But what is within our remit, we are very robust about it.
Thank you, Mr. Chairman. And that has helped me a lot because I've learned. It moves me to the next question, which is almost the same. It's something about power of separation. The Constitution Article 2 talks about supremacy of our Constitution. And then 93 to emphasize the fact that the provisions invest power in Parliament when it comes to dealing with the legislative power. But sometimes, I'm not a lawyer, I come across situations where we have a clash. Just recently, there was issue about, cannabis.
Cannabis, yes.
The other aspect, which is not legal, because I haven't read anyway, is I don't know exactly what they define in Ghana, because in most jurisdictions where they even bar the use of Indian hymns, they also legalize industrial cannabis because it has huge amount of economic value. There's so many countries. So even that law, I think we need to check and see which one we mean. And secondly, I want to find out between...
Let me try and deal with what you first said.
Okay.
I don't want the question to get too burdened. I think that you are referring to the constitutional duty or one of the jurisdictions of the Supreme Court, which is to ensure that any enactment or any act that is done in violation of the Constitution is not allowed to stand. And that is a function that we engage in all the time.
Are you done?
I'm waiting for his attention. That is a function that we engage in all the time. When when cases are presented to court, we do the evaluation, whether they can stand the constitutional standards, and then a ruling or a judgment is given. As the rest of your question, I think that I'm not qualified to answer it.
Chairman, thank you. The last one. Madam, this issue about freedom of speech and fundamental human rights, earlier one of my colleagues made mention of that controversial issue. I think a lot of people in our country today are abusing the fact that there is freedom of speech, so they can say anything at all. Sometimes a layman like me, just as I'm sure I'm committing some mistakes here legally, in terms of legal knowledge, I get confused that I can say anything at all. It doesn't matter how it tarnishes one's reputation in the name of freedom of speech. So where can we have clearly defined lines, or if there should be any explanation, so that we know where it starts and where it ends, and the other one starts and ends? Because I think it's giving rise to much controversy in our society. I want to find out. Thank you, Mr. Chairman.
I think we have enough laws around the subject. We have the laws from the law of tort, T-O-R-T. Then we have, in defamation laws, we have enough legal regimes around speech. It's about enforcement. It's about enforcement and people, and I think that it's critical to appreciate that society is dynamic. People the society is growing. We are exposed to different things, and so certain cultures will creep in, and so all of us have to be mature, and all of us have to assist and use the regulatory frameworks to ensure that we don't destroy the fabric of our society, and that we build the fabric of our society. Everybody has a responsibility. When it comes to us, we will discharge our responsibility.
Yes, Gisela.
Thank you very much, Mr. Chairman. Live pure.
Speak true.
To it, it's the motto of Wesley Girls High School. And she's an old girl, and she's my senior. Although I didn't meet her in Wesley Girls anyway, much younger. ladyship, on your CV, it says that sorry, congratulations, by the way.
Thank you very much.
On your CV, it says that you volunteered for 6 years with legal aid. Can you tell us the status of legal aid in Ghana today, and how decentralized are the services, and what you would do as Chief Justice and as somebody who has volunteered in that space before to make it accessible and more democratic to all? Thank you.
Thank you. I volunteered with FIDA, the International Federation of Women Lawyers, and I know that we need a lot more resources, so much more. The Legal Aid Board is functional, is a very busy board, but we need resources as a country. We need to lock hands together, ensure that the most vulnerable people have access. Sometimes the qualification, the criteria that qualifies you to access legal aid itself can put some people outside of it. And then sometimes people do not even know that it's a resource that's available. So more officers needed, more officers needed, more communication needed, and more resources made available.
Thank you. I believe
but it's something I certainly will not let slide under my watch.
That's good to know. Thank you. What signal do you think is being sent to Ghanaians in the diaspora on the dual citizenship, and the signals that is being sent with all the courts brouhaha going on around Honorable Kweson's case? What signal do you think is being sent, and what do you think you would do about it if you become Chief Justice to give comfort to the diasporan community?
You know, under Article 8 in the Constitution, we started out without even allowing dual citizenship. We have evolved. That article has been amended, and we have made several steps towards embracing Ghanaians who take on other citizenship. So I think that in terms of regulation, we are doing well. People have to read what has been put down.
So if we are doing well, then how does that stand with the Kweson's case?
When the reasons come out, you will read it.
Mr. Chairman, that means that I think, as you stated at the beginning, our vetting may be incomplete. Well, Madam, what's your ladyship, sorry, what is your view on judgment debts? And on whose part is a failure?
My personal view is that it's a big problem. It's a big problem because I think there are many cases that are not well defended. I think we need to look at the issue of how we apply interest rates closely. I think we need to look at how contracts are managed in the public space closely. Very often the transactions are in one ministry and have to be defended by the Attorney General's department. And I have come across cases where the relevant ministry is not giving enough information to the Attorney General's department for them to defend the matter. So I think it's a section of justice delivery that, as a country, we have to make ourselves alert to, and everybody with responsibility should pay attention to. I will do my part.
Thank you very much. On that note, I wish you well, and hope that as the Chief Justice, if approved, your era of leadership will be different, will be innovative. You will speak true and right the wrongs, and have impactful interventions that I believe you know, with all your experience in the judiciary, you know are very necessary to deliver justice in the system. Thank you very much.
Thank you very much, Honorable Member. All your words have been taken to heart.
Honorable Singh.
Thank you, Chairman. Honorable nominee, Mr. Chairman, let me, before I begin my questions, raise an issue that relates to maybe Parliament and our data systems and how they are kept. In my research for this exercise, I was shocked to realize that even though the nominee appeared before this committee only a couple of years ago, 3 years to be precise, 2019 November, this House has no record, verbatim report of her appearance. According to the people in charge.
Honorable Member, I think this has nothing to do with her.
That's why I said it has
so
nothing
we
to
will
do
deal
with
with
her.
it in the back room.
I said it has nothing to do with her,
So
but I
please,
just think that it is
candidates
important that...
Candidates, please, I beg you. Let's go back.
Mr. Chairman,
If, please, can I regulate it?
Yes.
What shortcomings there are in our administration is internal to Parliament. There are procedures for dealing with those ones. Now, we are doing the public. Please, you can make a statement outside of here, exposing how weak our systems are. But please, let's continue with the consideration of the nominee, please.
I appreciate that, Mr. Chairman, but you see, this is a public hearing, and the people out there hold us to higher standards, and they expect that if a nominee appeared here and said certain things, they will want us to know. And I'm saying that it's a big challenge that we have to resolve. We should not be, shy about it. We should fix the problem internally. So that it has to do with the committee, because I first went to the committee office. This is where I started looking for the information. Mr. Chairman,
to the question. I want us to avoid argument over this. Please go ahead.
I just don't want us not to have a record of this next year. Let's take note of this. And let's not think that I'm washing our dirty linen in public. I think that it is important that we fix our problems internally, because it helps improve the job that we do here. That's the point I just wanted to make. Thank you, Mr. Chairman. Now, I take note of the nominee's inclusion of Saki into her names, and she has said that she will submit the Gazette to update our record. And I particularly was excited about her reason for the inclusion. As a father of daughters, I am really excited about the reason for the inclusion of Saki. But it also gives me an indication of how strongly you are tied or related to family. And I would have ignored it, but I read somewhere about you being the niece of Major Sam Akwa, a very popular military officer who was the managing director of GIHOC, who unfortunately was murdered, under very bizarre circumstances in this country. You would have been about 20 years around that time, judging from your age. How did you have any relationship with him as a niece? How do you remember it? And has that impacted your choices in life in any way?
He was my mother's first cousin. I was in the university at the time. And yes, I remember the incident very vividly. I don't think it has impacted my choices in life. That's what I think that's the answer I can give.
All right. Let me move on now to, as a deputy ranking of the Lands and Forestry Commission, I am concerned about the use of state lands. Lands and Forestry Committee. Did I say commission? Leader, thank you for drawing my attention. I meant committee. I can't be ranking of a commission, so you should know I was referring to committee. I'm concerned